when we think about intellectual property in large part, we're thinking a lot about barriers to entry. I have a great idea, but can someone come along and eat my lunch by pricing it below me, by marketing it better than me, or by doing something different than me? You know, if no one's as good at you in designing, they can't necessarily come into your market. But if someone is able to copy what you've done, perhaps they can come into your market. Last year we launched something called the Founders Workbench. What we did is we put together a set of resources for founders of companies. And these are all free, and they're available to anyone online. You don't have to be a client of the firm, although we'd like you to be successful and become clients of the firm. But we have a blog, and we're on Twitter, and we're tweeting regularly, just ideas for entrepreneurs and startups. If you go over here, for example, creating documents, and again, you know, we caution people, you know, we're not giving legal advice here, but we're providing tools for people who need them. So, for example, incorporation documents, subscription letters, founders agreements, and the like. Some advice on how to get your business going, ultimately what type of corporate entity is best for you, how to best protect your personal assets, how to protect the money you're raising, usually, as Ted pointed out earlier in the first go-around, from family and friends, how to operate it. We do talk about intellectual property, which is where I'll go in a couple of minutes. And we include links to certain alerts that we put out and publish for our clients. And so, for example, on patents and trademarks, this newly formed startups talks about the role of IP for a newly formed startup. So we think it's, you know, it's a pretty good tool for entrepreneurs and for people getting involved in starting their own business. I like to think back in 1899, even before TEL 3000, the guy who ran the patent office came out and said everything that can be invented has been invented, and in fact he suggested closing the patent office. History has shown him to be wrong about that. And when you think about what is intellectual property, we know real property. You know, this building is real property. It's something physical. You can pick up, you can hold it, you can touch it. When we talk about intellectual property, we talk about the property in a sense of the mind. Ideas, creations, and things that are intangible. You can't hold them, you can touch them, but that doesn't mean they don't exist. And we talk about patents, trademarks, copyrights, and trade secrets. And if, as and when you're building a business, those are the types of protection you're going to want to start thinking about as to which of these forms of protection are going to best protect my business, are going to allow me to monetize my business, and are going to give me a competitive position in the marketplace. Copyrights protect expressive works, forms of protection, sculpture, films, music, and software. And copyrights are actually a lot more complicated than people think they are, because, for example, even in the music industry, you've got copyrights, you've got the performance right, you've got the lyrics, you've got the music, and then maybe you have a phonorecord, you've got a CD that has the music on it. So you could take this one piece of music and you could generate royalties by granting what are called sync licenses to allow someone to commit it to line up with film. You could grant mechanical rights, someone to reproduce the physical media that it's protected on. You could grant rights to the lyrics. You can grant rights to the music. You can grant a license for someone to sample your work, take your beat. Trademarks. Trademark is something that identifies a business. When we think of Apple, when we think of IBM, here when we think of Cosmo or Cosmo Girl. Trade secrets. Trade secrets are the ones that are probably least understood, but in a lot of businesses also provide a lot of value. Trade secret is, in a sense, exactly what it sounds like. It's something that you keep to yourself, that you've developed through an investment, whether it's sweat equity or economic equity, and its value is in the fact that only you know it. Most famous trade secret in the world is the foundation of one of the most profitable companies in the world, the Coca-Cola Company, and that is the formula for Coca-Cola. And there are two types of patents, and this, you know, again, in large part, relates a little bit back to what your business is. They're what we call utility patents and design patents. The utility patents, which are the types which I circulated around, those are things that protect something that is functional. They don't protect the idea, but they protect the specific functions of that idea embodied in something. A design patent protects the ornamentation of something, and it may not be as clear as I'd like it to be, but in the lower right, this is a design patent that was actually issued on the Statue of Liberty. On the left, I'm perhaps less proud to say, this is a design patent on the package for Lunchables So people talk about, why would I patent this? Why would I patent that? Even in big business, you can see the value of setting up that kind of a barrier to entry. And patents are interesting. They're tough to understand. They're technical documents in a way, but they are important to understand. And I think this is probably the most important part, because if you're going into a business that has some technology behind it, the real meat of a patent is what we call the claims. Flip to the back if you ever get a patent and you want to understand what it's about. When we think of a deed to a piece of property, it says it begins on the corner of Ocean Avenue and Avenue L and runs 250 feet east to a point in the middle of the street, and then runs 20 feet north, and so on and so forth. This is the same thing as the deed to the piece of land. This defines what they are protecting by that patent. And how do you get a patent? Well, first you have to invent something. And what is patentable is extraordinarily broad. It covers biotechnology, it covers plants, it covers products, it covers packaging, it covers electronics. There's a site, I think it's called applepatents.com or something like that. We can see a list, almost updated daily, of where Apple is filing for patents, the interfaces, the design, the looks. You can also start seeing what they're doing 2 or 3 generations ahead, because they're applying for patents now that are going to reflect what their products are going to be in the future. You file an application, the PTO, which are supposedly experts in this area, technically trained people, they kick it back to you, you respond, it's a back and forth, and sometimes they don't give you the patent. They say, listen, this has been done before, or it's too close to what's been done before, we're not going to give it to you. And you say, do you go to a higher court or do you walk away? It's a business decision. And so, for example, this is the core Netflix patent. The 381 patent, and this is an idea of something that they went ahead and patented, which is a method of renting items to customers, and what was quote-unquote unique about it was the max out feature, which allowed a specific number of items to be rented simultaneously to customers. And the patent office decided that that was sufficiently unique. And again, we talked about the idiotic. There's a patent that issued a while ago on how to tease a cat with a laser pointer. Patents are good for 20 years after they issue, after they're filed. These days, they recently changed the law. A common misunderstanding is a patent doesn't give you the right to do anything. It does give you the right to go to court and stop others from doing what's in your patent. Pretty quickly, trademarks we encounter more regularly in our everyday life. The words, and again, you don't own the word when you have a trademark on it. Again, think of Delta Airlines, Delta Dental, and Delta Faucets. It's the same word applied to different businesses, but over time in commerce, they've established an identity that people aren't going to be confused, because they generally will tend to use it in their market. Slogans, colors, pink is trademark for Owens Corning fiberglass for insulation. Trademark Office now gives trademarks for scents that have come to identify a business. And shapes, the Coca-Cola bottle is a classic example. The wasted Coca-Cola bottle is protected as a trademark. You're not required to register your trademark, and that's, again, there are advantages to doing it, whether it's on the state level or the federal level. What is important is, for example, if you don't have a federally registered trademark, perhaps you want to put TM next to it, because you want to notify the world that you consider this to be your trademark. There are advantages if you have to go to court or sue to stop others from having a registration. It's important, it's not a necessity, and if finances are right, we recommend it because of the advantages. But again, when you're showing it to the public, when you're putting your public face out there, why not brand it with a TM, not an R with a circle, because that way you begin to let others know, I consider this to be my identity in the marketplace. What is a copyright? Copyright really we think of as a bundle of rights. If you think of picking up a bundle of sticks, it's a bundle of rights that protects something that is creative. Like patents, it's in the Constitution. And when you own a copyright in something, let's say it's a piece of music, let's say it's a film, you and only you have the right to reproduce it, to create derivative works, shortened versions of it, distribute copies, which is an important right, to perform it publicly, and to display it. Those are the rights which make up the copyright. And again, those are divisible. In other words, I can license you the distribution right, I can license you the performance rights. Your copyright springs into existence upon creation of the work. Again, registering your copyright is inexpensive. I think the fee is up to $35, and it's a form that's downloadable at copyright.gov or the Library of Congress website. But again, there are advantages. You can get attorney's fees if you have a registration, someone infringes or violates your copyright. You may be able to get what's called statutory damages, which is up to $250,000 per copy if someone intentionally and willfully violates your copyright. You can't get that with a non-registered copyright, but you can sue to stop them, and you can sue for your own losses as a result of what they've done. And what is included: literary works, if you write code, musical works, dramatic works, choreography, sculptures, motion pictures, architecture. What is not copyrightable? The title of the work itself, and I know this may be an illusionist sore point,
right,
given the animated version that came out, the animated film that came out this year with the same title as The Illusionist.
Yes.
Titles are not copyrightable. Titles of a series, though, may be copyrightable. Titles of or trademarkable, but titles of a single work are not copyrightable. IP allows you to corner the market, which is the traditional reasons. License revenue, and this is an ongoing lawsuit. Someone has a method patent for executing future trades, and they have sued the futures industry, and they don't want a lot. They just say, give us 3 cents for every trade that's cleared. And when you think about it, 3 cents may not be a lot, but how many billions of trades are cleared through the futures exchanges? The money is mind-boggling. So they allow you, if you license your patent, and again, one of the most successful people I know, he was a plumber. He had a better idea for a certain washer, which he then licensed to industry, and he's collecting a royalty on every washer sold with this particular structure, and he's sitting in his house in Florida and golfing 7 days a week. There's another guy, Jerry Lemelson, who recently passed away, who established what's called the Lemelson Foundation. He had a patent on basically the barcode and barcode scanning equipment, and that portfolio generated $500 million a year in revenue. Jerry never sold a thing in his life. He invented, and he got patents, and he licensed them. Mistakes. Complicating the company formation. Again, you need to think through on day 1, if not day 0, how are you going to structure yourself, because it's going to impact on tax liability and exposure. Having your founding team, and again, this is sometimes more defined for technology companies, but you want to make sure that you're getting the right number of founders in and people who are adding value to the team. Failing to pay attention to the corporate formalities. Again, it's going to be important down the road, especially if you're looking to raise capital, that you have the right structure, that you can give the right rights. Falling in love with your own idea. Science, technology don't build a business. Selling items, selling services builds a business. Failing to understand commercialization, how you're going to get there. Again, you need to see the monetization at the end of the day. Don't worry about it. Failing to raise enough money or spending it too quickly. Biggest danger for startup companies, one of the biggest dangers for startup companies is there's no, and I think this is the best, there's no right answer to the question of how much money do I need. And finally, you've got to do what you guys are doing here, which is one of the most important things. You're looking for advice, you're taking the right courses, you're learning how to persevere. I have no doubt is giving you passion for the idea of building your own business for the right reasons. And stick with it.